My Lord, if I may, they're using into my time. They will have time to respond. Yes, the judicial report was. I can proceed.
I have a specific question. We want to know in which case file in the portal, because that's the submission my colleague has made. There's this internal memo. First, I want to know the internal memos are normally in the portal. I'll be glad to learn. But more importantly, in which case file is this internal memo so that we can authenticate? That's simple. My colleague Dan will say this in the portal. He has a duty to furnish us with the particulars.
Yes, we have indicated, my Lord, that it is in the physical file. My Lord, Mr. Nyamodi will specifically address him with that so that I can proceed, my Lord. My Lord,
please, the applicants, when you are submitting, the respondents gave you time. Please just give them time to make their submissions. You are going to respond. There will be time for you to make a rejoinder.
My Lord, the proceedings before you are in the public interest. They are in the public interest, and therefore the question of time management, my Lord, and the need for expeditious disposal of the application before you cannot be overstated. My Lords and your Lordships, time and again, my learned friends have submitted that whereas this court can sit at odd hours where it receives an application, that in matters as mundane as the current matter before you, that this court should have had this matter in the course of the day. Of course, no doubt, my Lord, this court has moved to the electronic age where matters are transmitted through mail and through other forms, my Lord. My Lord, but most fundamentally, we are here to challenge ex parte orders, not inter parte orders, not orders given inter partes. And my learned friends therefore cannot speak from both sides of the mouth that where you are dealing with matters of the impeachment of the deputy president, such as this, that ex parte orders cannot be issued, yet they obtained ex parte orders that necessitated the filing of the application before you. My Lord, what we are dealing with here is a removal under Article 145, and which the law defines as final under Article 145(7) of the Constitution. When therefore my learned friends submit about the office of the Deputy President, they seem to forget that Article 145(7) refers to the finality of the Act of Senate. And therefore, all the orders obtained under the subject, Mr. Hamino, just give me time. All the orders obtained under the subject of this proceeding, my Lord, were obtained after the impeachment proceedings, after the act of impeachment. And it is therefore important, my Lord, in the interest of all of us, that these matters are resolved expeditiously and timelessly, so that this court can move to the next phase. And the next phase, my Lord, would be dealing with the question of the next step. My Lords and your Lordships, it is clear that my learned friends do not want to proceed to that phase. And that is, we have all these multiple applications and the inability of the applicants to want to be confined to the question of time. They want to speak throughout the night. On our part, we want to sanitize this proceedings, my Lord, and stick to the point that the application does not meet the threshold set out for recusal, because recusal is also a prayer in this. They have advanced no reason at all to want this court to recuse itself or to find that it was not empaneled in line with Article 161, 163, 52A of the Judicial Service Act. We opine, my Lords, that this bench was properly constituted by the Deputy Chief Justice, exercising powers donated to her by the Chief Justice, unless they're saying that there's another Chief Justice. Thank you, my Lord.
My Lord, my ladies, as a follow-on to the submission by my two learned senior colleagues, I wish to respond further to the application as follows. There has been a lot of water under the bridge since we convened, or since this court convened at about 11:15 or 11:30 this morning. But as I am no doubt members of the court will be able to quickly figure out, the single issue that is before you is a challenge as to the regularity of this, of the referral of the 3 or 4 matters to this bench by the Honorable the Deputy Chief Justice, the Deputy Chief Justice of the Republic of Kenya. And I wish to commence my response to that objection by saying as follows. The Chief Justice occupies 3 distinct constitutional offices. 3 separate and distinct constitutional offices. First, the Chief Justice, by dint of Article 161, Sub-Article 2A of the Constitution of this Republic, is the head of the judiciary. By dint of Article 163(1, the Chief Justice is the President of the Supreme Court. And by dint of Article 248, Sub-Article 2E, the Chief Justice is the chairperson of a constitutional commission established under Chapter 15 called the Judicial Service Commission. Members of the court, I wish to take just a moment to demonstrate how the Chief Justice is deputized in these 3 distinct constitutional offices. In respect of her capacity as the President of the Supreme Court, Article 163, Sub-Article 1B is clear that the Chief Justice shall be the President of the Supreme Court, A, and that B, the Deputy Chief Justice shall deputize for the Chief Justice and shall be the Vice President of the Court. That is the first constitutional office. The second constitutional office is the head of the judiciary, and I will come back to Article 161 in a moment. Suffice it to say that it is in Article 161, Sub-Article 2, that the office of the Chief Justice is established. And Article 161, Sub-Article 2 states as follows: there is established the office of the Chief Justice, who shall be the head of the judiciary. I will come back substantively to 2B in a moment. But it is important that for the purposes of the commission established under Article 248, Sub-Article 2E, the Deputy Chief Justice is then not the Vice Chairperson of that commission. In the Judicial Service Commission, the DCJ does not deputize the Chief Justice. Now, it is our position for the respondents that the function that the Chief Justice exercises under Article 165, Sub-Article 4 is the function set out in Article 161, Sub-Article 2A. That is not the President of the Supreme Court, that is not the chairperson of the Judicial Service Commission, but that function is exercised by the Chief Justice in her capacity as the head of the judiciary. It is our submission that therefore the Deputy Chief Justice, who is the Deputy Head of the Judiciary, by dint of Article 161, Sub-Article 2B, can exercise the functions of the Chief Justice as Deputy Head of the Judiciary. And members of the court, Article 161, Sub-Article 2 creates 3 positions: the Chief Justice, the Deputy Chief Justice, and at Sub-Article C, it creates the office of the Chief Registrar of the Judiciary. Now, the Chief Registrar of the Judiciary doesn't deputize the Deputy Chief Justice. But the Deputy Chief Justice deputizes the Chief Justice. That does not require any interpretation. That is really comprehension as a matter of English. It is then for the Deputy Chief Justice, in instances where the Chief Justice is unable to act as the head of the judiciary, the Deputy Chief Justice can then perform that function. Members of the court, I submit that the decision in Lina Conchela is good law. And the facts in Lina Conchela are important. When you retire to consider your decision in this matter, you will note that the only respondent in Lina Conchela was the Chief Justice. The only respondent in Lina Conchela was the Chief Justice. If, for the sake of argument, we go along with the submissions made by our learned colleagues for the applicants this evening, that the Deputy Chief Justice then cannot deputize for the Chief Justice, then in Lina Conchela, when a judge of the High Court certified that the issue in that matter was one fit and proper for an expanded bench under Article 163.4 or 165.4, then going by the argument, then there would be nobody to empanel the bench because the Chief Justice was a party. How can he or she empanel a bench in a party where there are respondents? That is the absurdity in the argument by the other side. And my Lord, it is our submission, or it is our position, that the Constitution of this Republic must remain elegant and it must remain functional. Interpretations such as the ones urged by my learned colleagues for the applicants that would lead to that sort of an absurdity should be rejected by the court. It is my position, as I am on my feet this evening, as I have been consistent, that the Constitution says what it says. But the Constitution only means what the courts of law in the Republic of Kenya interpret it to mean. And it is the interpretation of the Constitution that gives it life, that gives it meaning. And, my lords, my lady, it is therefore my submission that it is a proper interpretation of the Constitution, flowing from the express provisions of Article 161, sub-article 2A and B, that your empanelment was regular. As I take my seat, I wish to submit that I am in no doubt that as you sit as the three judges presiding over this matter this evening, you have no doubt as to the regularity of your empanelment. Because if you did, and flowing from the accolades that have been heaped upon you by learned counsel for the applicants, then you would not touch this file. There are other files that are equally urgent, that deal with the same issue, that have been brought to your attention this morning, this afternoon, and maybe again this evening, where you have said, in the absence of that direction, under Article 165, sub-article 4, you are unable to deal with those matters. So, my lords, my ladies, being satisfied, or you being satisfied with the regularity of your empanelment, this application is for dismissal. And I must add, with costs. So that the important substance in this matter can be determined by the court. I'm most obliged.
Thank you.
My lords, my lady, permit me to just conclude with giving a bit of a context in the Concealment matter. I'll not go into explaining anything because, my lords and my lady, the decision speaks for itself. The decision is a decision of 5 judges of a high court. In particular, my lords and my lady, paragraph 97 is instructive. 97B in particular, if I may, reads that the exercise of powers under Article 165(4) of the Constitution, though constitutionally underpinned, is administrative in nature. They go on to add that being administrative in nature, the said mandate can be exercised by the Deputy Chief Justice when the Chief Justice is absent, when necessary, or if for good reason the Chief Justice is unable to exercise the mandate. At D, they conclude that in the present circumstances, the rule against bias and the rule that no person shall be adjudged in their own cause dictates that the Chief Justice, being the main respondent in the instance petition, could not assign judges to hear the petition. My lords and my lady, that is the absurdity that learned senior counsel, Professor Githu Muigai, was talking about. Take it a step further. Is it therefore their case that if, as contemplated by their lordships in that matter, if for one reason or the other, the Honorable Chief Justice is unable to perform the functions of that office, is it therefore their case that no matter that requires constitution of a bench will be heard or determined? That certainly would be an absurdity that the law would not have contemplated. That said, my lords and my lady, one of the things that will play out by close of business these submissions is that our learned friends from the other side have very deliberately taken to concealing what would otherwise be material information before this court. I say that for two primary reasons. I want my lords and my lady to make reference to their own application, to the grounds supporting the application. They start, the application is based on the affidavit of Honorable David Munya Mathenge and other grounds. The other grounds include A, that on the 18th of October 2024, the petitioners herein filed the instant petition together with an application under certificate of urgency seeking conservatory orders restraining the assumption of office by the second interested party pending the hearing and determination of the application and petition. They go on to say that on the same day, the matter was placed before the Honorable Justice Mwongo, who considered the matter, and in light of the urgency of the matter and the weighty constitutional issues raised, the Honorable Judge issued the conservatory orders sought in the first instance and certified the matter as raising weighty constitutional issues and referred the matter to the Honorable Chief Justice to constitute a bench to hear and determine the petition. This is where now the story starts. That on the next day, being Saturday 19th October 2024, the petitioners were surprised by the turn of events wherein they were served with the order of this Honorable Bench stating that the first and second respondents' applications dated the 18th October 2024, in bracket the applications for were to be had for their inter partes hearing on the 22nd of 2024. Why do I say there is deliberate concealment of material facts? It is because, my lords, looking at the files that were coming up before this court today, that is E565 of 2024 before the court in Nairobi, and E015 of 2024 in Kerugoya. We immediately, upon learning of the orders that had been issued and which have been adverted to here, filed an application. It is on record. That application, my lords and my ladies, sought several prayers. One was that we wanted to have that application certified urgent. Like in their case, our application was certified urgent. Again, we asked that the court considers hearing the application outside the normal court hours, including a possibility of being heard on a Saturday. My lords and my lady, that prayer was not granted by the court. We also, as a third limb of our application, asked that the court considers granting an ex parte order staying the decision of the Honorable Justice Mwongo and the Honorable Justice Mwaita in the Nairobi matter. Again, my lords and my lady, that prayer was not granted. What followed was then the court, as would be the normal practice of that court, gave directions on how this application was to be dealt with. That is how we ended with the date of 22nd of October 2024. And why this is important, why is it their case that when they file an application and get orders, it is convenient, it is okay, there is justice. When they get another order in Nairobi, it is okay, there is justice. When we get an order merely certifying our matter as being urgent, then there is, all hell breaks loose. And we are saying, if only our colleagues had sought to present this material before this court, we would not be talking about what we're talking about now. It would have been manifestly clear that we were here on account of an application. My lords and my lady, I've had very strange submissions coming up this afternoon. Submissions including that at the ex parte stage where the court is supposed to be giving directions, the parties expected that they ought to have been given notice. Since when, my lords, do the courts in this division, and indeed any other division, attend to matters under certificate, and at the ex parte consideration of those orders, invite parties for hearing of those orders? Why then do we call them ex parte? That submission, my lords and my lady, I repeat, is not for the consumption of this court. That submission can only go to serve an audience that is outside this court, because the people in this court are fully aware of the rules governing the conduct of matters in this court. My lords, allow me a few more minutes just to point out a few other areas which then would speak to the reality of why then the omission of this material fact is then now being used to place this insinuation that the court either did something that was untoward, or the Honorable, the Deputy Chief Justice did something that is untoward. My lords and my lady, at paragraph D, the respondents in the application say, subsequent to the reference of a matter to the Chief Justice on the 18th, the petitioners reasonably expected that once the Chief Justice issued directions on the file regarding empanelment, the petitioners would also be invited for mention before the bench for directions as was directed by the Honorable Judge. If they didn't have an application, on what basis, therefore, was an order going to be issued to them? One would have expected that that would be something that would come from a party not represented. But a party represented would certainly be talking to an audience other than this audience. At paragraph G, my lords and my lady, they say they now have a direct accusation on her ladyship, the Honorable Deputy Chief Justice, say that the Deputy Chief Justice violated Article 1, 10, 27, and 50 of the Constitution in ordering this bench to hear and determine 3 matters in which conservatory orders had been issued against the government of Kenya and its organs, namely, then there is no such order that came from, and a perusal of the file would speak for itself. All that the Honorable, the Deputy Chief Justice did was to constitute the bench. And if anything, this same bench is a bench that had been constituted by the Chief Justice herself. Questions that we ask ourselves. Why is it that when we appeared before this very bench last week on Tuesday, on there is the issue is on the other side, it becomes irregular? That cannot possibly be a parity of arms when you're dealing with a question of justice. Why is it that when they went all over asking for orders, and this speaks to why there are only 2 matters that came before this court, they filed a number of cases. In those other cases, there were no orders. What business did we have filing applications in those matters? We only felt that we were aggrieved with these orders specifically because the effect of those orders were to suspend a provision of the Constitution. And that's why it's important for us that we deal with them. As we seek to deal with them, the only way that the rules of this court establish is that we make an application. My lords and my ladies, I look at, finally, I think, their ground number L, that they also sought to know the circumstances that led the Chief Justice to delegate to the Deputy Chief Justice. That, I think, has been spoken to. My lords, my ladies, what then comes out is that if our counterparts had been candid with the facts in the file as they speak, we would not be wasting time as we are right now.
we would have had an opportunity to speak to the matters on the basis of the accuracy of the files. We would not be casting aspersions on the court as we have seen. We would not be casting aspersions on her ladyship, the Deputy Chief Justice, as we have seen. We will not be casting aspersions on the Chief Justice as we have seen. My lords and my lady, I repeat that that submission is meant to achieve two reasons, and two reasons only. One, to delay the proceedings that are before you today. We have an application, and at the right time we'll be seeking and insisting to have it heard. And number two, to then create this negative impression, which I suppose is meant to be used at a later stage. I rest my case.
Thank you, my lords and my lady. My name is Morugara. I wish to submit only on 2 points of law which were actually articulated in support of the application. And these were that the proceedings before this court touch on the Bill of Rights, and they are vitally important that we should actually not be seen to flout the Bill of Rights. The Bill of Rights is Chapter 4 of our Constitution, runs all the way from Article 19 to 50. But I wish to remind the court that the Bill of Rights applies to every party that comes before the court, and it's not just one party. The proceedings we have before the court are very important to the petitioner. They are equally important to the respondents. And it goes without saying that over 50 million Kenyans actually have an interest in these proceedings, and this is the reason why the agency has been certified both ways. My judges, aspersions have been cast on the bench so as to call for this recusal and application of Article 165(4), that you're being drawn into a conspiracy to commit injustice because there is no emergency that requires you to hear this matter as a matter of urgency. Far from the truth, the two applications that are before you to set aside the conservatory order are as important as the applications that led to the granting of those orders. Therefore, the hearing of those applications must be speeded up, and we are able to move with the matter ahead. You've also been accused of being enlisted in service of the violation of the Constitution. Again, far from the truth, because this is an allegation being made against you, while the position of the respondents is that justice must be served expeditiously and as required by our Constitution. Finally, Article 165(4), which uses the word assign and not appoint. Inasmuch as this is a constitutional responsibility for the Chief Justice to assign, it is purely administrative. The word used is not appoint. We are using other words like empaneling and what have you. But, sorry, the word used is assign. And therefore, if the Chief Justice is not able to assign, nothing stops the Deputy Chief Justice from making the assignment. That is number one. Number two, where it is expressly provided in this Constitution that in the absence of the Chief Justice, the Deputy Chief Justice would act, relates to Chapter 9, when the Chief Justice is dealing with the executive. In this particular instance, we are dealing with the judiciary, where the head of the judiciary is the Chief Justice, deputized by the Deputy Chief Justice. So I also urge you to find that, in fact, there was nothing wrong with the Deputy Chief Justice in the absence of the Chief Justice assigning the judges who were to deal with these two applications that were before them that particular day, and the next applications which had been filed previously. Thank you.
My Lord, in 2 minutes, my Lord, as you retire to consider the application, Milimo is my name, my Lord. I would invite you to consider Article 259, my Lord, Sub-Article 3, and particularly, my Lord, B and C thereof. And if you allow me, my Lord, I'll read it out. And it states that every provision of this Constitution shall be construed according to the doctrine of interpretation, that the law is always speaking, and therefore, among other things, B, any reference to in this Constitution to a state or other public office or officer or a person holding such an office includes a reference to the person acting in or otherwise performing, my Lord, underline, otherwise performing the functions of the office at any particular time. My Lord, it's not disputed that the CJ was out of the country, and that, my Lord, the DCJ was performing the functions, my Lord, of the CJ at that particular point in time. And, my Lord, our attention have been drawn to the communications of the CJ that had particularly asked the DCJ to take charge. My Lord, therefore, Article 259 3B provides an answer to the question that is before you. And, my Lord, lastly, I'll read Article 259 3C, which reads, my Lord, and it says, a reference in this Constitution to an office, state organ, or locality named in this Constitution shall be read with any formal alteration necessary to make it applicable in the circumstances. My Lord, the circumstances before you were that the CJ was not available to give the directions or assign the bench. What the DCJ did, my Lord, was applicable in the circumstances. I invite you, my Lord, to refer to that provision when you'll be making your ruling. I thank you.
My Lord, I represent the Speaker of the Senate. And, my Lord, allow me to make very brief submissions without repeating what my colleagues have said. My Lord, allow me to start by quoting Article 145, paragraph 7 of the Constitution, to just contextualize the reasons for our application on Friday last week. My Lord, if you look at the provisions of Article 145, paragraph 7, my Lord, the impeachment of a deputy president is a serious national stability matter. My Lord, because after a vote by the Senate, in accordance with Article 145(7), the deputy president, my Lord, it says at least 2/3 of all members of the Senate, when they vote to uphold any of the impeachment charges, the president shall cease to hold office. In this case, as contextualized, the deputy president, the former deputy president, in this case, Mr. Rigathi Gachagua, ceased to hold office. My Lord, look at it also in the context of Article 22. My Lord, this former deputy president, in exercise of his right in the Bill of Rights, my Lord, moved the court by way of a petition. My Lord, on Friday, that's 18th of October, 2024. My Lord, conservatory orders were issued, which, in accordance with the petition, with the respondent's perspective, appear completely problematic. And, my Lord, they required immediate intervention in terms of the respondents, my Lord, moving the court. Because, my Lord, the flip side of Article 22 is that whereas you have a right to file a case in court and seek conservatory orders in accordance with Article 23, paragraph 3A, a conservatory order which is discretionary. it means you are suing a respondent. My Lord, that respondent equally has a concomitant right to move to court, to interfere, to set aside, to ask the court to vary that conservatory order. My Lord, the grant of that conservatory order is discretionary. So, my Lord, there is nothing cast in stone in terms of the respondent, my Lord, coming to court to make an urgent application for the setting aside of that conservatory order. My Lord, there is also nothing strange for the court in public interest. My Lord, for the court in public interest, having looked at the grounds of this application to set aside these conservatory orders, my Lord, for the court to apply Rule 3 of the Mutunga Rules, my Lord, to make a just, expedient, and my Lord, proportionate decision in terms of directions on how to dispose of this matter. My Lord, again, under Section 60 of the Evidence Act, we all need to take judicial notice of the fact that my Lord, now we have the e-filing system. My Lord, when such extraordinary matters come to court, my Lord, the court is empowered, my Lord, at any time, my Lord, at any time of the day, my Lord, at any time, to access the system, and my Lord, to give appropriate directions for the expeditious resolution of this dispute. My Lord, they benefited from these orders on Friday. My Lord, unlike them, my Lord, we had the courtesy, because my Lord, we saw the court orders in the social media, and we responded accordingly. But my Lord, unlike them, we were courteous enough to serve the orders which were issued by this court to the respondents. So it cannot lie in the respondent's mouth to say that they have been ambushed to come to court, to the extent that they come to court and say that we are acting under protest. We did serve them with these court orders. And my Lord, on the last aspect of that point is that, my Lord, then this petitioner who has come to court under certificate of urgency, my Lord, having absented himself at the Senate on Thursday for health reasons.
Lord, may I please on record?
I think that is okay. That is not proper.
See, my Lord, I'm just winding up, my Lord, to emphasize the
But
contradiction.
he did not absent himself. Sickness is not absenting himself.
My Lord, I can rephrase. My Lord, I can rephrase. My Lord,
But
this
you can
petition.
as well avoid it.
Yes, my Lord. This petitioner.
May I say he apologized?
Let him avoid it.
Yes, yes.
Let him
Yeah,
avoid
my Lord,
it.
I'm avoiding actually
Yes,
that.
yes. Yeah, he has avoided it.
Justice administered without mercy and wisdom is not justice. Here you got someone who is in his 60s, he is saying he's sick, he has cardiological problems, and we come and play it down. These are principal advice of the government. They must do whatever.
Yeah, I'm actually concluding. My Lord, can I now conclude?
Have you withdrawn that?
Yes, my Lord, I was making a contradiction by saying that the petitioner was able to access the court expeditiously, and the court was able to grant him conservatory orders on Friday. My Lord, the same petitioner cannot then come to court and complain. My Lord, complain when, my Lord, the Chief Justice, my Lord, the Deputy Chief Justice, my Lord, in public interest, and given the extraordinary nature of this matter, my Lord, gives directions that this bench be constituted for purpose of determining the underlying question. My Lord, the petitioner cannot probate and reprobate, can't speak on both sides of the mouth. So, my Lord, the other extraordinary nature of this matter, my Lord, is that the petitioners have filed a multiplicity of suits. My Lord, you have heard that there were 3 cases in Ikerugoya alone. My Lord, other cases were filed in Nairobi. My Lord, Kenyans, and my Lord, this is the consumption of justice. My Lord, just a few days ago, the Chief Justice had appointed this bench to determine these matters for the satisfaction of Kenyans. My Lord, in the public domain, Kenyans are aware that this bench has been appointed. So, my Lord, what is wrong? What is so different? What is so strange for the Deputy Chief Justice when the Chief Justice is away? Again, for the same reason, for purpose of expediency and my Lord, for purposes of laying a multiple basis for consistency in judicial decision making, for these matters to be brought before this bench by way of a directions in terms of uses being used of this matter. So, my Lord, I don't see anything extraordinary. My Lord, as I wind up, the petitioners have just simply cast aspersions to the process of appointment. There's nothing cogent. My Lord, I don't see any integrity issues with respect to the handling of this matter by the Chief Justice. I don't see any integrity issues with respect to the handling of this matter by the bench. So, my Lord, our plea, my Lord, our sincere plea is that the underlying dispute with respect to the setting aside of the conservatory orders, my Lord, in accordance with the directions which were issued, shall be urgently determined, my Lord. My Lord, in public interest. Thank you.
My Lord,
So, my Lord, for the fifth respondent, I'll be very brief. I just wish to
remind us of your
yes,
name.
Dr. Kamodo, I appear for the fifth respondent, for the sixth respondent now, in the new order. First, I wish to set the record straight in terms of some misrepresentation that has been made with regard to the decision cited, the Reina Conchera decision. When the petitioners were submitting, they were not aware that I am one of the petitioners in this matter and that I am fully versed with the entire set of facts. So they misrepresented that the matter is not active. Nothing can be further from the truth. This matter is active. It was mentioned on 24th of September 2024 before a new bench that was constituted following the accession of the honorable judges who were previously dealing with it, and it is due for further mention on 30th of October 2024. So the decision remains solid in terms of its capacity to persuade you not to depart from it, because no reason has been supplied, save for the misrepresentation that it should not be utilized. Now, allow me, my Lord, to make reference to the High Court Organization and Administration Act in light of the issue that has been raised on the sittings of the court. I will briefly cite verbatim Section 10 on the sittings and recess sessions of the court, where it is couched as follows: that the court shall subject to subsections 2, 3, and 9 sit continuously for the trial of criminal cases and disposal of civil and other legal business of the court. There is no disclaimer whatsoever with regard to the time that the court should sit. So the court can sit at any point in time, day or night. Indeed, today, when dusk came, I was apprehensive that counsel for the petitioners might leave, since the court is sitting past working hours, presumably. So the point that must land home is that nothing prevents this honorable court from sitting at any time, such that then the issue of when the court sat, when the files were transmitted, when the orders were released, whether on Saturday, whether on Sunday, though it has not been shown that is what transpired, the court has liberty to sit on such occasions if need be. With regard to the issue of the empanelment by the Deputy Chief Justice, again on this account, the petitioners have misapprehended the import of Article 165(4), because what is fundamental is that there be a substantial question of law, and that question of law is certified on the discretion of a High Court judge. What that means is that the same issues that are being heard here today could have been heard by even a single judge if at the discretion of the judge who handled the matter reasoned that there was no substantial question of law. So what the Honorable Chief Justice or anybody else capable of exercising the powers within the office of the Chief Justice does, anybody else capable of exercising the powers within the office of the Chief Justice does, is administrative. All the High Court judges are qualified to deal with matters of such nature. All of them. So assigning one or the other is routine. It is purely administrative. There is nothing that is exceptional intellectually in terms of or requiring a special exercise of powers when it comes to dealing with that aspect. So in a nutshell, I would wish that, to point out that in a hurry to come to court, the petitioners even wrongly enjoined the sixth respondent, His Excellency the President, when Article 143(2) is clear that no civil proceedings can be instituted against the President. A decision that has been affirmed by the Supreme Court in the decision of Attorney General and 2 others versus D and 79 others. So the Supreme Court made an express order that the President cannot be sued. It's an order. So the proceedings that have been lodged before this court have been filed in contempt of the Supreme Court decision, and they should amount to nothing in the full and final set of facts. So I'll be seeking that the bench continues to stay put so that as early as possible, I can seek to have the sixth respondent discharged from the irregular proceedings initiated by the petitioners, and which they don't want concluded. They want to thrust this country into a crisis. Under Article 146, there is possibility of the office of the President becoming vacant on account of various issues, either through death, which is uncertain, through resignation, because he can tender resignation and decide that I think I've had it too much, he can tender resignation, or any other reason that may arise. So at the moment, upon the Senate voting on the first ground of impeachment, we stood without a deputy president. So what would happen in the event we have a vacancy in the office of the president? We are staring at a crisis. We don't have a deputy president. The Honorable Speaker of the Assembly can only serve for 60 days. We don't have an IBC. So what the petitioners are doing is fomenting a crisis of monumental proportions, which we will not be able to imagine about. So I humbly pray, my Lord, my Lady, that you find favor in the arguments of the respondents and dismiss the application by the petitioners. I'm most obliged.
If they are over.
But my Lord, I didn't clarify one thing. I think one of my friends I've been referring to the judge at the right of Justice Murima. It is Murima.
Well, I grew up in a school. I don't have a problem over there.
Are you the only person submitting now on this side?
Yes, I'm in my minutes, 20 minutes. I want to do 20 minutes. They were 20 minutes, yes. No. And I said I'm doing 15. Mr. Ongoya will do 5. No. He asked for 20, I'll do 15.
All right.
And Camino, because of seniority, is asking for 5.
So you use how many?
No, I have to use 15. There were very many people. So I need 15 and give Mr. Ongoya. We need 5. Let me start at least for one point. My learned colleague, Mr. Legua, whom I respect a lot, is saying that probably we start with the 2 points raised by a learned colleague, Mr. Joseph Kamoto. My Lord, the first thing, okay. My Lord, the first thing is that the President cannot be sued. My Lord, for purposes of my understanding of the Constitution, everyone under the Constitution of Kenya is subject to the law. That is what the Constitution says. There is nothing the Supreme Court or any other court can say as valid law to change that position of the Constitution. So to the extent that the Supreme Court, assuming it ever said such a thing, that cannot be good law in the face of the Constitution saying everybody is under the law. Second point, my brother, what is the nature of the proceedings? These are not civil proceedings. These are constitutional proceedings. If Article 149 of the Constitution says the President shall do this, there is nothing in Article 156 that would entitle the Attorney General to be sued on behalf of the President. Because the Constitution itself says the President shall do this. My Lord, also, if this is Bill of Rights enforcement, if the petitioners are saying the violator of the law is the President of Kenya, then the mandate of this court is to ensure the President does not violate the Bill of Rights. Nobody else can be sued on his behalf. I think we have done with that preliminary issue. Oh, and there is these issues of vacancy. My Lord, I was imagining that if this vacancy is troubling anybody in Kenya, 2 things. Number one, you would have seen some urgency in reconstituting IEBC. Some of the petitions that are before you or that will find your way to your hands are also saying the President cannot do what he's so desperate to do because there is no IEBC. So that is coming. So if there is any urgency, anybody who cares about vacancy, let us start with IEBC. My Lord, also, if, and I think Kenya are entitled to this information, Mr. Kamogo appears so late that a vacancy in the office of the President may arise. Perhaps this is information the people of Kenya are entitled to. Why is that so?
My Lord, it's purely conjectural. It's an
Right,
illustration.
I'm not saying anything. I've ended there.
Unless you have some plans.
I don't know. I did say it. I did say it. Yes, my lord, now coming to the main issue. My lord, this forum, when somebody said we are sitting past the desk, it made me remember something. I think I saw the presiding judge was practicing at some time, and I was practicing as a lawyer in the 1990s. And I remember going to court very many times with the Kakaminoa, Paul Mwite, and Gibson Maukuria. What was it all about? My lord, during that time, and when we would go to those cases, there was no distinction that was made.
My lord, with your very kind permission, I'm constrained to just want to get some clarification. Are we re-urging the application? Because the role you have, Senior, and you know it, you are supposed to be responding to issues that have arisen. I don't think what you're speaking to has arisen, and there is no latitude that extends to that in that general direction.
Yes.
My lord, we would want to get some guidance on that.
My lord, I believe those...
Mr. Kibe, you made the clarifications earlier, but now just stick to the reply according to the...
My lord, one of the cases that during that time, because, you know, we can't address every true issue. I'm trying to be good about it. My lord, one of the, and these are global points I'm making with regard to the issues that have been raised. My lord, you are effectively being told the petitioner and the respondent occupy the same space from the standpoint of our constitution. My lord, the truth is the judge. And I say that for the simple reason that these constitutions of Kenya was made explicitly to protect citizens who can suffer from harm from the executive and people who occupy power. That is what the protections are meant to do. Conservatory orders are given to ensure people whose rights are being violated and in need of protection, that protections will be accorded. So somebody to say that an application for conservatory orders stays on the same level with an application by a violator to continue or to complete the violations, my lord, that would amount to misreading the Constitution. And this is not an idle issue. Under Article 20, it is very clear. The Constitution binds all state officers and this court. So the notion that we have a right to be heard, yes, when we shall be doing the petition, give them 10 hours and we shall not object. But let the subject matter be preserved. We've got no problem. The right to be heard under Mutunga rules is protected. But there is a distinction under our Constitution between a violator and the victim of violations. That one is very clear in our jurisprudence. But having said that, there is another office. There is a question of the empanelment, whether you call it assignment, appointment. The issue is, for purposes of Articles 165 of the Constitution, does the Chief Justice exercise judicial or administrative powers? I go with what Dr. Kaminwa says. These are judicial powers. And judicial powers, my lord, takes us to the oath that is prescribed by believing the third schedule of the Constitution. When the Chief Justice says, takes an oath, is to exercise the judicial powers that includes, with regards to the High Court, the powers under Article 165(4) of the Constitution. No such oath is taken by the Deputy Chief Justice to enable her to do so. So that, my lord, as long as, if you say it is administrative, we go to another level. The questions would be, can this be made without a formal judgment where the issue has arisen directly? Because as you were told by my learned colleague, Mr. Waduta, that matter is still yet to be decided by the Court of Appeal. But having said that, there's a question my learned Professor Muigai, whom I learned a lot from him. My Lord, Professor Muigai talks about public interest, the issue of the necessity for it, and about a vacuum arising. Well, the happy thing about the Constitution is that up to this time, the petitioners have done nothing that would elongate the time at least of 74 to 100 days that is envisaged under Article 149 of the Constitution for this business to be conducted. If anything, it is this kind of applications to set aside that will prevent these petitions from being heard, for example, in the next 30 days, so that there is still some other 30 days for the people of Kenya to be consulted on this issue and the regular decisions to be made by Parliament. My Lord, there is the issue that an absurdity is being created. Who is creating an absurdity? The absurdity, my Lord, that is being created is this. And strictly speaking from Article 25 of the Constitution. Article 25 of the Constitution says the right to be heard is absolute, even during an emergency. How can this right ever be absolute, and this court were to take away the subject matter before that right is exercised, and you do not call that an absurdity? We are actually here to prevent that absurdity. In fact, you can have a ranking of absurdity. The biggest absurdity, my Lord, would be this, Article 125. All rights under Article 24 can be limited. Under Article 25, the right to be heard is absolute. It is binding on everybody. That's the biggest absurdity that can occur. Who supports that absurdity? The respondents. My Lord, we go next to Professor Ojienda. Of course, Professor Gedu said many things which you cannot deal with all of them. This internal memo, where is it? Oh, it's here. It's here. My Lord, this internal memo, first of all, we note, when the question was asked, is it anywhere? It is not in the CTS. Start. Number two, or portal for the cases that have actually been filed. My Lord, the second issue, there is no replying affidavit for this court to be able to deal with it. But what does it actually say? It says, during my absence, I request you, your ladyship, to be in charge. I will, however, be available on email or telephone for consultation. My Lord, the last sentence, plain meaning of English, would mean to me that Chief Justice from Geneva or anywhere else she was cannot be able to carry out certain administrative functions. But when she says that to be consulted, this was clearly made in the knowledge that there are certain things that I must do, notify me so that I can do them. The appointment of judges could be made by the Chief Justice in accordance with the constitutions from Geneva. My Lord, I could have said more. There is no much time. My Lord, they say they are challenging ex parte orders. My Lord, what ex parte orders is the main issue. The ex parte orders we are challenging is a conservatory order to ensure that before this court there will be integrity and the constitutions will be upheld. And the kind of circus we had in Parliament will not happen before you. My Lord, my Lord, for purposes of where do we want this matter to be completed? My Lord, they said this is that they want the matter to be completed. We are more desperate for this matter to be completed. And that is why in the expectation of the petitioners, we expected that the first business of this court, like it happens every time I sit on benches, and I've sat on very many, they say, this matter is very urgent, we cannot hear preliminary matters, let's go straight to the petition. So we are very desperate to have this matter heard. My Lord, there is my learned colleague, Mr. Nyamodi, whom again is a good friend of mine I respect. CJ occupies 3 constitutional offices, I agree. But the only issue of distinction is under Article 165(4) of the Constitution, she cannot be able to perform that function any more than we could say she could transfer judges. Transfer of judges is actually more or less administrative, but she doesn't do it because it is an important office that goes with the office of the Chief Justice. But if this is judicial, she cannot be able to do it. My Lord, the issue of Conchela, again, the issue is contextual. The Chief Justice was a party, and therefore in Conchela, as far as I am concerned, the matter, the Deputy Chief Justice did so as an acting Chief Justice. Even Gachagua or anybody else who gets into that position, when they are acting as acting president, there are certain decisions that they can make, but they must wear that position. In this letter, there is nothing that suggests that the Deputy Chief Justice was turned into an acting Chief Justice by the CJ. Equally importantly, there is no express delegation that my powers under Article 165(4) would now be performed by the Deputy Chief Justice. My Lord, the issue of Gumbo came with some funny issue on concealment of material facts. I do not know. I struggled to listen that we have concealed anything. Now, as anything, we actually even did an affidavit. They had a right to do an affidavit. It is not indicated that this document, which was in our possession, as I understand the law of disclosure, we failed to disclose it. All the other issues they are raising are points that are in contention. That does not amount to concealment, as I understand it within the law. My Lord, there was the question that no basis for Getonga Murugaro. Getonga Murugaro, I'm trying to rush. Murugaru, okay. Murugara, okay. Sorry. Oh, that's okay, my friend. My Lord, he says, and I agree with him, that this matter is very important for the 50 million Kenyans. I could not agree more. A matter that is so important to 50 million Kenyans, the least that could be expected is that proceedings are going to be conducted in open, without suspicions, without undue hurry and pressure. But my Lord, if the petitioners, and already they are feeling, I'm feeling pressure that I started to do, if the petitioners feel that they are under pressure in a certain matter, that is not an express emergency under the constitutions of Kenya, it leaves a big question mark. If for some reason there is a desperation to turn businesses that the constitution say you should do it within around 80 to 100